Have you ever been asked to sign a document full of legal jargon and just signed it? You're not alone, especially when it comes to non-disclosure agreements or NDAs. It feels like a standard formality, but what are you actually agreeing to? Let's break down the fine print so you know exactly what's inside. First up, the duration. How long are you sworn to secrecy? An NDA isn't a life sentence. Most have a set time frame, typically ranging from 1 to 5 years. For highly sensitive information, like a secret recipe, it could be indefinite. But for most business dealings, there's an expiration date. Always check this clause. If it seems unreasonably long, it might be negotiable. Next, let's talk about scope. This is the what of the agreement. What information is considered confidential? A well-written NDA will be specific. It might list things like financial data, customer lists, business strategies, or proprietary software. Be wary of NDAs with overly broad language like all information exchanged between the parties. That's a huge red flag. You need clarity on what you can and can't discuss. If it's too vague, you could accidentally breach the contract just by having a casual conversation. Now for a crucial part, carve-outs. These are exceptions to the confidentiality rule. Carve-outs specify what information is not covered by the NDA. This usually includes information that's already public knowledge, information you independently developed without using the confidential data, or information you rightfully received from another source who wasn't bound by confidentiality. Another important carve-out is for legal disclosures. If a court or government agency legally requires you to disclose the information, the NDA shouldn't prevent you from complying. These carve-outs protect you from being unfairly penalized. Finally, let's discuss enforceability. Can they actually sue you if you spill the beans? The answer depends heavily on where you are. NDA laws vary significantly from state to state. For example, California has laws that limit the use of NDAs in settling harassment claims. Some states might find an NDA unenforceable if its terms are too restrictive, like if it prevents you from working in your industry for an unreasonable amount of time. If you move from one state to another, the enforceability could change. The NDA will usually specify which state's laws apply, known as the governing law clause. This is a critical detail, especially if you're working remotely across state lines. So, what happens if you break an NDA? The consequences can be serious. The disclosing party can sue you for damages, which means they can seek financial compensation for any harm your disclosure caused. This could include lost profits or damage to their reputation. They might also seek an injunction, which is a court order forcing you to stop sharing the information. In some cases, you might have to pay their legal fees as well. It's not something to be taken lightly. Before you put your signature on that dotted line, take a moment, read the duration, understand the scope, check for those important carve-outs, and be aware of the enforceability in your state. An NDA is a powerful legal tool designed to protect sensitive information, but it should also be fair. If something seems off or overly restrictive, don't be afraid to ask questions or seek legal advice. Knowing what's inside the fine print isn't just smart. It's essential for protecting yourself and your career. Thanks for watching. If you found this breakdown helpful, give this video a like and subscribe for more insights into the world of business and law. See you next time.